Welcome back to the show. Attorney Seth Nurbass is our guest today, and the hot topic is all about intellectual property. And we have several great questions from our viewers, and we're going to get to those in just a few moments. But before we do, Seth, explain to us again, for all of our viewers out there, what is it that people can do on their own? What shouldn't they do on their own when it comes to taking care of this issue?
They can attempt to register a copyright on their own. They can, in some cases, try to register a trademark on their own, but I recommend they use an attorney. But they're not likely to mess something up so badly that it can't be fixed if they do a trademark, try to register a trademark on their own. I definitely do not ever recommend that they try to file a patent application on their own, because they can cause irreparable harm to themselves. They can lose all rights to their invention by filing a patent application on their own that doesn't adequately protect the invention.
Oh, that's very important to know.
Yeah, and let me add to that. You know, in personal injury and workers' comp, there are certain cases you can get a free initial interview with the attorney, and often in those types of cases you pay nothing unless the case produces results. In your area of law, can people come see a patent attorney such as or intellectual property attorney such as yourself and other attorneys who do what you do and get an initial consultation? How does that work? Okay,
at our firm we will offer an initial consultation, usually up to about 15 minutes at no charge, or we'll take the client to lunch and at no charge over lunch talk about our clients or potential clients' needs.
Is that unique, or will other attorneys in your business give an initial talk just to give a general idea, and then if it gets more detailed, they'll charge an hourly rate?
I suspect other firms do what we do with a free initial consultation, but I can't speak for other firms.
Yeah. And to recap, if it's a patent, that's very complicated, and you don't recommend to anyone they try and do that on their own. But if it's a trademark or a copyright issue, that's something that people may be able to do on their own without needing an attorney.
Okay, definitely for a patent, you need an attorney. You need a competent patent attorney, an experienced patent attorney preferably. You can sometimes do a trademark registration on your own. If you mess it up, it might be fixable. You can, in almost all cases, do a copyright registration application on your own, because if you mess it up too badly, you can typically refile.
Okay.
Not a big deal.
Ballpark figure, what does it cost for the different ones?
Okay, if you need an assistance of an attorney for a copyright registration application, typical case, $3,000 to $5,000. I'm sorry, $300 to $500 for a copyright registration. For a trademark registration, often $1,000 to $2,000 in a relatively simple case. For a patent, sometimes it's as little as $6,000 or $7,000.
Wow.
Often it's 15 or 20, sometimes more.
Yeah.
It depends on the invention, how complicated it is, whether it's chemical, computer related.
It's very, that's an investment, and so you want to make sure that you do get it right. Let's get to some of our viewer questions here. Cheryl says, do I need to copyright a magazine that I am in the midst of publishing? Is that something she needs to do?
No. If she's in the midst of publishing, she can wait until she's finished.
Okay.
Copyright protection is automatic, as we've talked about. There are some advantages to registering, but then it costs money to register, even if you do it on your own. I think the government filing fee is $35 or $45, I don't recall offhand. But if you register everything you come up with, it adds up.
Okay, yeah. And so once you register, that's it. You only have to do that one time, right? That's not something that you have to keep doing after a period of time.
Right.
So register one time only, done deal.
Right.
But she doesn't have to do that until she's done.
Right.
Okay. All right. Our next question comes from TJ. He says, can I print a t-shirt that says Go Tigers and sell it without the permission of LSU? I could be talking about anybody, the Detroit Tigers. How would anybody know?
Right. Well, he could do that. However, he'll likely get a letter from LSU's attorneys, because they will say, look, Go Tigers, you may mean the Detroit Tigers, but when you're selling them in Louisiana, people assume that it's authorized by LSU. And courts will likely back up LSU in a case like that.
Especially if it's Go with the G-E-A-U-X.
Right.
Because they don't do it like that in Detroit.
Right.
Right. Okay. So very important, TJ. Stu writes in. He says, "Is it legal to rip a DVD that I've purchased so that I can play it on my iPad? I'm not sharing it with anybody." Can he do that?
It might be. In some cases, you can make a copy of something that you purchased legally for your own personal use or as a backup. And so I believe that under the current state of the law, that is legal. But if he does that, he can't then give away the DVD to someone else and say, here, now you can use my DVD.
Oh, so it just has to be for his personal use.
Right.
He can't share it with friends and family, in
Right.
other words.
Right.
Okay. All right. Well, we have another question here. Now, this one, we talked earlier about a slogan. This question is about creating a logo. When an artist creates a logo for a company, who owns the copyright to that logo?
Okay. It's complicated. It might be the company, it might be the artist who created it, or it might be co-owned. Typically, it's going to be either the artist or the artist and the company. The best thing to do is, if you're a company and you're going to hire an artist to create a logo for you, have a written agreement saying, I will hire you to create a logo either on your own or with the company, and the company would like to own all copyright rights in the logo.
Okay, very important.
And get that signed in advance.
It's very important, and I can imagine that, this could be, something for a formal arrangement or an informal arrangement, because if you've got a friend who's a graphic artist and you're saying, hey, look, I just need, a logo for my company, could you create something? You might not automatically think, oh, I need to get some sort of agreement. There needs to be an agreement between the two of us.
Right, and you wouldn't think about it, but you should do it, even if it's a friend of yours, because when you go to sue someone for infringing your rights in the logo, if you don't have clear title to that logo, you may not be able to pursue a copyright claim in addition to a trademark claim.
Okay, all right, very important. Another question. I took a great photo of Drew Brees at the last Saints game. Can I print that on T-shirts and sell them?
Well, you can, but again, you might get a letter from Drew Brees' attorney. In general, a public figure like Drew Brees has publicity rights. And you're infringing his publicity rights when you take a photo of him, put on T-shirts, and sell it.
Yeah, well, okay, so let's say it's not a celebrity, though. Let's say it's anybody, anywhere. Take a picture of anything, anywhere, and I decide, I think I might be able to make some money on this.
Okay.
And I decide to print it on this, that, or whatever.
Well,
can I do that?
If it's a pretty waterfall, sure. If it's John Redmond, well, John may be too famous. Maybe he has rights of publicity. But let's say it's your friend's child, 5-year-old child. Then you don't have a right of publicity, you may have a right of privacy. So the best thing is to always get permission from the model before you reproduce a photograph of a model.
What if you are at the game and you got a picture of Drew Brees and you want to post it on Facebook? I see that all the time.
Yeah, that should be okay. There's a limited right of fair use, that's right.
Okay, all right. Here's another great question. Can an employee copy software bought for her office computer to use on her home computer? Is that legal?
That depends on the agreement with the copyright provider. And you know those agreements where they say, click here if you want to use the software?
But nobody reads.
And that nobody reads.
That no one reads.
Exactly.
Right. They used to be called shrink wrap licenses because they were in a shrink wrap and you'd have to tear the shrink wrap, read the license before you could get to the software. So you really need to read the.
You really need to read the agreement
that license and see what it says.
Yeah, because you could.
Because sometimes it'll say you can use it at home and at the office, or it may just say this is for one computer, or it may say it's for up to 5 computers. You need to read the agreement.
Okay, all right. It says our next question says, if the photo on the internet does not have a copyright notice on it, can someone copy it legally?
No. Copyright protection is automatic in the United States and in most countries. When you create something, whether it's a photo, a short story, a novel, you own a copyright from the moment of creation.
Okay.
And so just because you find something on the internet without a copyright notice doesn't mean you can copy it. There is no requirement that you put copyright notice on anything that you create.
That's very important.
Very good.
Very important. So many more questions. We just don't have time to get to those, Seth. It's just been such a pleasure to have you on the show with us today. But don't go anywhere, because before we leave you, we want to let you know that we are going to be posting more of our interview with Seth. We're going to have an extended interview on johnredmondpoa.com.
Thanks to Seth, and thanks to all of you. Remember to tune in each week and every week on LAE.